Hey, boys, look what I got here.
Hey, where are the white women at?
You know I had to do it. I had to do it. My wife asked me, you play that every time? I haven't before, but I'm starting to now. Blame Mike White and Mike McClune and a bunch of other guys for that, because why? It's funny as hell. So anyway, what's up, guys? So in between homework, bunch of reading on advanced ballistics and a bunch of other things. You know me. I started doing a little research, trying to find different cases, Supreme Court cases, oral arguments to listen to, all the stuff that, my wife just thinks I'm insane for listening to. But anyway, so I came across an interesting one, and we're going to listen to it tonight. And let's ask everybody in the chat, do you think that 2 rounds of 40 caliber, too many choices favorite round, are worth going to prison for 2 years over? Now, throw out some things in the case. What's up, Z? G23, hope you're feeling better, brother. So let's throw out some things in the case. Yes, the woman who got caught with the 240 caliber rounds was a convicted felon for identity theft, nonviolent felon. I wouldn't have given a shit if she was a violent felon. I really don't care. 2 rounds of 40 cal, no gun. She got pulled over on a traffic violation, I think. Wrong turn, blinker, something like that, something stupid. The cops literally searched her vehicle for about an hour to find 2 rounds of 40 cal. This chick got pulled over in view of her home. Matter of fact, where she got pulled over, her husband came out to the scene, which wasn't far from their driveway, and explained to the people that, yes, that was his wife's car, but he used that car. He was a valid FIOD card owner. This is from Illinois. Haha, funny, because look at what Illinois is doing with all their gun laws right now. This is where we talk about one step after another. Now it's assault weapons bans and all this other bullshit. So I couldn't download the audio for this case like I've done with others. So I'm going to have to do a split screen on this one and play the audio while we sit around and shoot the breeze about it. DLD, what's up? No felony on God's green earth that takes away from a person's natural right. Yeah. And especially considering, again, this chick was, yes, she was a felon. She was a non-violent felon. In other words, she wasn't out freaking doing drive-bys and all kinds of stuff like that. You couldn't prove that she had any violent intent. And on top of that, her husband was a valid FIOD card owner. This would very much be like if me and my wife got together. I was still prohibited at the time. And my wife used my truck. My truck was in my name. My wife used my truck. She goes hunting. She leaves ammunition in my truck. And I get pulled over and I have ammunition in my truck. And, here you go. Someone wants to prosecute me for, felon having ammunition. These are the insane things that we talk about sometimes where we don't have a criminal justice system anymore. We just have a system of the government putting people in prison or other things. Because there's absolutely no justice that you can find in this woman's case. I haven't listened to the whole, this went up to the Illinois Supreme Court. That's where these oral arguments come from. I can't remember whether it went any further. And I think the Illinois Supreme Court actually upheld this while my wife's making her adjustments. You want to show them what you have in your bra?
Oh, you want to do the magic trick?
You guys don't get happy because it ain't them.
Grab.
Yeah. I don't share. I don't play well with others, so I ain't showing you nothing besides a snake.
That's my little buddy.
And yes, I'm going to smoke this because if I don't smoke it now, it's going to get stale and then I'm going to be pissed. So let's see. Let's see how we're going to start this off. Let's do a screen share. And we're just going to share the entire screen, share it with audio. And I'm going to shrink this down and scoot it over.
No, buddy.
And let's bring this up. Let's see, where am I at? People v. Jones. Okay.
The second case on our call is number 127810. That's People's State of Illinois versus Taranza Jones. Agenda number 11. Counsel for the appellant.
You guys throw an F in the chat and make sure you can hear this stuff pretty good. Yeah, Dark Man, I looked for your stream last night, didn't see it, and I ended up crashing. So
Morning, Your Honors, Counsel. May it please the court, I'm Daryl Lohman, and I represent the appellant in this case, Taranza Jones. The primary issue facing this court is whether it's permissible for the lower court to affirm a conviction of Mrs. Jones for the presence of 2 bullets buried in the glove box of her car under the owner's manual and a stack of other papers. The car that she shared with her husband, who was a legal FIOD card holder and a gun owner in the state, while she herself was not one. The car contained no firearm, however, just the 2 bullets that were buried in the bottom of the glove box. And the state does not contend that Mrs. Jones is the person who put them there. The facts of the case are, I'm sure Your Honors are aware, are very clear, but for the benefit of our guests, Mrs. Jones was subject to a traffic stop. The officer searched the car over the course of the better part of an hour and eventually found the 2 bullets in the glove box. He brought the bullets back to Mrs. Jones and she said, "Those are my husband's bullets." And in fact, the traffic stop occurred so close to Mrs. Jones' house that her husband was awakened by the flashing lights from the police car, came to the scene and showed the officer his FIOD card and said, "These are my bullets. We share this together. I take this car with me when I go to visit family in East St. Louis. I responsibly separate my handgun when I'm transiting from my ammunition."
So this is in another thing when we get started on this, okay? So criminal laws are supposed to protect the public from some criminal who is preying on the public and harming people, robbing them, raping them, murdering them, all this stuff. This is in Illinois where they came up with the firearms owner identification card and all this other shit. And you take a woman on a traffic stop, nonviolent. Cops have to search her car for almost an hour to find 2 rounds of ammunition. No gun, nothing. Is it honestly worth that woman going to prison for 2 years? Logically, in your heart of hearts, in your teeny tiniest little heart of hearts, is that worth someone going to prison for 2 years?
Keep the clip, perhaps a box of ammunition in the glove box. I keep the handgun itself in the trunk. And what obviously happened in this case, and I don't think the state disagrees, is that when you remove the bullets from the glove box, 2 of them fell out. Now, how many of us could confidently identify every single item in our glove box? This is especially difficult when you share the car with another individual. I'm sure some people have very tidy glove boxes. I'm not one of them. To me, the glove box in my car is no different than the junk drawer in my house. Things are placed in there, dropped in there, forgotten for months, for years. I cannot, if you ask me today on my life to give you a list of everything in my junk drawer or my glove box, I cannot do it. I do not, in any meaningful sense, know what is in that glove box. And that's the issue here today.
That's the issue here today, is the issue of constructive possession, correct?
Yes.
What if these were drugs?
This court's and lower courts case law concerning.
Now, and I'm sorry to have to stop this so quick again. This is where we get into, again, constructive possession. What have we heard about with a lot of things these days that the government talks about? If you have this part that could be a silencer or suppressor, that's constructive possession. What happens if you have these parts that are locked in a different place than these parts, but you could put them together at some point in time? Constructive possession. Constructive possession is horse shit. Always has been, always will be.
Drugs or handguns are largely identical. They're treated as contraband. The issue is knowing possession, whether you knowingly possess a gun, or in this case, firearm ammunition, or possess heroin or cocaine. With respect to the mens rea, which is the issue before this court and the issue at trial, the case law is largely the same.
Again, if for those of you who don't understand, mens rea means intent. In other words, you knew the law, you said the law, and you did whatever anyway. Mens rea is intent to do that.
Under the appellate court's reasoning, though, a person seems to be automatically charged with knowledge of the existence of anything found in his or her car.
Yeah, that's definitely the major problem in this case, is that essentially what the state's arguing for is a strict liability application of the law, which is contrary to the legislative clearly, or perhaps a negligence standard, because they spent a lot of time talking about what she should have known, that she had some invented duty to search her car, every nook and cranny, to see if there's any bullets in there, based simply on the fact that she knew that her husband brought his gun with him when he traveled to East St. Louis, and then removed it from the car and put it back inside the house when he returned home. Again, I don't think there's any dispute, and I'm sure the state will correct me if I'm wrong, that explains the presence of the bullet. The state has offered no other explanation. There's no contention that Mrs. Jones had 2 bullets and nefariously placed them in her own glove box, or that it's analogous to a drug courier case where she's a bullet courier and she's trying to transport these bullets somewhere else to sell them. Those are not the facts of this case. This is far more.
I want to talk about the law of constructive possession.
Mhm.
We have lots and lots of cases of construction possession where people have been convicted, the convictions have been upheld, where there have been found contraband in a car. How is this any different than any of those other cases?
Well, there's cases both ways, respectfully.
Pardon?
There's cases both ways. So in some cases, of course, it's confirmed. In other cases, it's not. And it hinges on what the actual central element in this case is, not just constructive possession, it's knowing possession, which is the language in the statute. So there are cases.
Any other cases where, for example, a handgun is in the glove box where the defendant has been convicted of constructive possession?
Where it's been reversed, you mean?
No, where it's been affirmed.
Oh, where it's been affirmed? No, not without
There are
some
no cases in
indication.
the state of Illinois where someone has been found guilty and it's been affirmed under constructive possession of a contraband in a car, for example, in a glove box. There are no cases that have done that?
If that's all the evidence in the case, or if there's additional evidence showing that there's some reason to believe that the defendant was aware that the contraband was present in the car. That's the important distinction here. So there are numerous cases that go both ways based on the evidence in the case. There's a recent case from this court, People versus Wise, which I'm sure you're aware, but other cases cited in my brief, People versus McIntyre. The appellate court reversed, where the driver of the car did not know. There was no evidence that the driver knew about the handgun that was concealed in the car. People versus Hampton, another second district case. So there are cases going both ways. They hinge on the facts of the case. And the facts of this case are.
Can you tell me about one of the cases that where the court found there was constructive possession. How are those cases different factually from this case?
I can't off the top of my head, I'm sorry.
So that, okay.
Speak to the facts of a case where the defendant lost. I'm sorry, I haven't prepared that today, but I can't speak to the facts of this case. And under the facts of this case, there was no basis provided by the state to indicate that she did know that the handgun was in the car, which is the issue. The issue is knowing possession. And again, there's also a question about what does knowing possession mean? Knowing possession means that she was consciously aware that the bullets were in the glove box. And I don't think there's really any argument that she was consciously aware of that fact. Now, the definition, the statute, and in the IPI continues. Consciously aware includes an awareness of the substantial probability that under the facts of this case, the bullets were in the glove box. No, it's not strict liability. You're not just tasked with the knowledge implicitly. It's not a negligence standard. It's not even a probability standard. It's a substantial probability, which is consistent with just what do we mean when we say consciously aware? What do we mean when we know knowing? Significantly, of course, the jury did not receive the IPI in this case. They specifically asked the court for a definition of knowing and were shut out. The court did not issue the instruction. And under this court's case of People versus Childs and numerous other cases, there's two problems with that. On one hand, the court has the duty to instruct the jury when it asks. And also, on the other hand, the jury is entitled to receive that definition. It's clear under the facts of this case that the jury was struggling with the central issue in this case, knowing possession, not just constructive possession, but what did she know? What was she consciously aware of?
Mr. Ullman, didn't the court find in, with regard to just two facts, that the defendant correctly guessed the bullets belonged to her husband when asked about them? And the other fact that the court used was the defendant's husband testified that she knew he transported his firearm in the vehicle. Those are the only two facts that we know in the record here that she should have known or she knew.
That's essentially what the appellate court said, but those facts and other facts in the appellate court opinion are not correct. They're not supported by the evidence. The husband testified the procedure I discussed earlier, that he would, when going to East St. Louis to visit family, he'd bring his gun, he'd store the ammunition separately in the glove box. He did not testify that she knew that. Though Mrs. Jones testified in this case, she did not testify that she knows that. She's not a gun person. The state cites the case of People versus Hammer, where you have a husband and a wife, and the husband's a gun person, the wife's not a gun person. And the officers went into the house and they found the guns, and they didn't charge the wife because they weren't her guns, but they charged the husband because he didn't have a FIOD card. The difference in this case is the husband in this case has a FIOD card. They couldn't charge him, and they shouldn't have charged her either. It's frankly outrageous that she was charged under the facts of this case and that she stands before you convicted of a felony because her husband accidentally left two bullets in the car.
Well, the husband did testify that the defendant knew he transported the gun in the car, correct?
Yes.
I mean, he testified to that. And then the way that, again, this is all phraseology, but the way the appellate court put it was that the defendant immediately identified the ammunition as belonging to her husband, tending to show that she knew it was there.
Right.
I mean, that's what they looked at. And again, you cited the standard of substantial probability. That is a standard, but we also have to bring that back to the Collins standard. Any rational trier of fact could have found someone guilty under these facts.
Well, Your Honor's referring to what the appellate court opinion says, as I mentioned earlier to your fellow Justice Burke. That's not supported by the evidence. That's what the appellate court's opinion says. But if you look at the actual testimony, this only came up at the very end of the arresting officer's testimony. And the prosecutor, just as a last question to wrap up, said, quote, "When you told the defendant that she was going to be arrested on possession of the ammunition, did she make any voluntary statements to you?" And the officer replied, "She did. She said that the ammunition was her husband's." No further questions. There's nothing about how it was.
They get into, in a minute, they get into the timing of the statement. Her saying that's not my ammo and trying to make this deal, though. She said it pretty fast. Well, yes. Her husband used the car. Her husband has a gun. Her husband has a valid permit FIOD card, which is absolute horseshit. So obviously she knew if there was any ammunition that got left in the car, it was her husband's. It's very simple. But I wouldn't care whether she had a gun in the car loaded. If she was not harming anybody else, I don't care. But these are 2 rounds of .40 caliber ammunition and this chick gets to spend 2 years of her life in state custody, and I believe under the identity theft that was her first felony, I don't think she spent any time in jail for that. I'd have to read back through her the case notes because I've got the transcript and everything. I've read through that. But if we're supposed to these laws are supposed to be protecting the public from dangerous people, there's nothing that I've read about this chick who says she was a danger to anybody. Is it worth taking someone's freedom and putting them in incarceration for 2 years for 2 rounds of ammunition? I wouldn't give a shit whether she had 20,000 rounds of ammunition. Think about it. If she had a standard box of 20 hunting rounds, like we buy, I go to the store, I buy a box of 30-06 because I'm deer hunting. I leave that in my wife's car. If she went to jail for 2 years for 2 rounds, what would they have done for 20? For someone who was not a violent threat to the public.
She didn't seem surprised, how she immediately responded that she leapt at the conclusion. There's dash cam video that was provided in discovery to the attorneys in this case, but it's not introduced. We don't have the timing that the appellate court ascribes to these statements.
DLD, damn right. That's all I'll say. Let's let this play.
Is not present in the officer's testimony or anywhere else in the record. Okay, so I think it's important to point out that she didn't leap at that. Another important thing, again, similar to the husband and wife and Hammer, or I mean, any of us really, if something belongs to a husband and it's associated with a husband, such as the guns and hammer, the bullets in this case, it doesn't require a pause. It doesn't require any thought to say, what is that? Whose boxer shorts are those? They're my husband's. Whose size 6 shoes are those? They're my son's. They're not mine. I wouldn't fit into those. I don't have bullets. I've never had bullets. I've never fired a gun. I don't wear size 6 shoes. I don't wear boxer shorts. The timing is not on one hand, not in the record, and 2, not important to the question of whether she knew that the bullets were in the car, whether she was consciously aware that they were in the car. Yes, it's possible. We know it's possible because they were in the car, right?
And who decides that?
Sorry, Your Honor?
And who decides that? Whether you're saying maybe she knew, maybe she didn't. Who decides that?
The jury decides it after being properly instructed.
See, this is where the Quash, if you guys don't remember them, Safety Doc show with the Quash, this is where you get into jury nullification. This is where you get into when a jury sees a case that is so damn stupid, even if the law is written in text, black and white, thou shalt not. If the law is so stupid, even the jury goes, no, we're not making a decision on it, or we're saying not guilty. That is our only real defense against some of these just absolute asinine laws, is if people wake up and they just refuse to convict. So-and-so had a machine gun. Was he killing anybody? Nope. He had 10 machine guns in his basement. And the entire jury looks at the judge and goes, not guilty. But you have the instructions that machine guns are illegal. And the jury as a whole goes, I don't care. Your laws are stupid. So therefore, we're not going to convict on them. That's where cases like this should go. Unfortunately, the vast majority of this country are sheep. And if it's the law, it's the law. Why'd you throw them in the gas chamber? It was the law. It was passed by the majority of people. If you have 100 people in a room and 99 people vote to take my natural rights, that shouldn't matter because they are my natural rights. The majority doesn't get to rule. Just because you have more people than me doesn't mean you get to come eat my lunch for free. But hey, we got a justice system, right? I have no idea where this is going to go.
I mean, my second point, as I mentioned earlier, they were not. The jury struggled with this issue. I mean, in a broad sense, knowing could be an entire topic of a philosophy class.
Let's talk like lawyers here. So you're saying that, what is your legal argument? They received all the proper instructions, correct?
No.
No?
The jury was never instructed on the definition of knowing, even though they specifically asked for that instruction.
And is there, why was it error not to instruct them on the definition of knowing? What case are you citing?
People versus Childs, which is a decision of this court.
In which every question that's asked by a jury must be.
Okay, let me unmute myself. In the notes for this case, the jury sent back a note to the judge and said, we need to know the definition of knowing. And this is where we get to our legal code being so fucked up. Knowing should be as simple as she knew, she was cognizant, she knew that the rounds were in the car. And there was some go back in between the prosecution and the defense, and there was part of the legal code that if it was read right would have meant she knew it even if she didn't know it. So the defense attorney was like, no, I don't want to do this because that part of the code reads this way. So they basically, the jury got sent a note that said, knowing is your own definition of knowing. It's if you know, you know. Some of my issue with that is because they didn't get sent basically a definition that said if she doesn't know completely 100% those rounds were in there, then she's not guilty. That kind of instruction was never sent to the jury. So what it is you have DAs and prosecutors and all these other dickheads that are involved in this that are willing to take a woman's freedom for 2 fucking rounds of ammunition. Knowing, if nothing I read says she has a violent background, knowing she's no threat to the public. This is another case of the only person or the only entity, person, whatever, that was harmed by her action was the government and their rules. And fuck any cop who would prosecute under a situation or press charges under a situation like this. Cop who found that shit in their glove compartment should have tossed the shit on the side of the road and been like, hey, fuck it, we're out. At least from what I read. Unless you can prove she's some violent kingpin on things.
Answer, is that your position?
If there is an IPI, yes, absolutely. Even the rules of this court, the Supreme Court rules itself, I don't have the number off the top of my head, but it said in my brief that if there's an IPI, it must be given. Now, does it have to be given in the initial packet? No. If you look at the committee comments of the one IPI at issue in this case, the committee comments are clear that they don't necessarily have to be given in the initial packet. And it cites a case called People versus Powell that says, if the jury's okay with this, perhaps under the facts of any given case, it's fine. But once the jury asks, yes, under People versus Child, this court said, not only does the court have a duty to instruct the jury, but also the jury is entitled to receive that instruction.
Mr. Ullman, so what your argument really is that because this jury wasn't instructed in having her know, did she know about the bullets? It really leaves speculation. It's like they just are guessing whether she knew or not because they weren't instructed to answer the question.
That's right. We know that they did not have any basis to make this conclusion. As I was saying earlier, you could teach an entire philosophy class about what it means to know something. It's not within the ken of the average juror, but it's certainly not within the ken of these particular jurors because they asked. They said, please tell us, what does it mean? What does knowing mean? And they were not instructed, and that's error.
So what happens? Let's talk like lawyers. What are the issues here? The jury asked for a definition of knowing.
That's right.
And trial counsel agreed not to give a definition, correct?
Ultimately, yes.
All right, so what's the framework we're talking about here? Ineffective assistance of counsel? What do we?
It's definitely forfeited. In my briefs, I've argued ineffective assistance of counsel, and I've also argued both prongs of the plain error doctrine.
So you know, let's put all this in some context.
Sure.
What is your argument? Is it sufficiency of evidence? Is it an instructional error? Is it plain error? Is it ineffective?
Okay, so here we go, Crow. There are a lot of laws out there that are absolutely unjust and retarded laws. Simply following the laws is where we get to a place that just simply having a gun on you is all of a sudden a crime. It's written in law. There were more people who voted on it than people who didn't. Even though I have tons of different reasons I could have a gun on me at any given time. Long gun, short gun, handgun, you name it. But it's the law. And see, police are sworn to uphold the Constitution. The Constitution does not allow shit like this. And it hasn't ever since the Constitution was written. But all of these people, including those judges sitting up there, swear an oath to the Constitution. So this is where I have my biggest issues with a lot of these things that go on where, well, was it against the law? Yes. Well, they deserve to go to jail. No, because the law itself is unjust. This is my argument with a lot of people, and I've come about this through a very roundabout way for a very long time. The laws, just laws, should actually protect innocent people and should harm criminals. That's a just law. But we don't have just laws anymore. When you have a situation where the government is the only one who is harmed by something, and their law is thou shalt not, I'm sorry, that's not just. So a police officer in this situation, if you are going to enforce laws, you should be an authority on laws if you are going to enforce them. Matter of fact, you should be a constitutional fucking scholar at that point if you're the one who's going to enforce these things. And the Constitution doesn't give you that fucking power. This might turn into one of them angry streams, kids. Just warning you.
Assistance of counsel, what framework should we be putting on your argument?
Well, the briefs contain two arguments. One is sufficiency of the evidence. The second is the jury instruction issue. They're somewhat conflated in the sense that how can an improperly, incompletely instructed jury be relied on to correctly reach the central issue of the case? So there are two alternative grounds. As your honors well know, if this court finds that the evidence was insufficient, it should reverse outright. On the second issue, if it finds that either counsel was ineffective or it's plain error under either prong to incorrectly instruct the jury when they ask for the instruction, then you still need to reverse, but it goes back for a new trial. Hopefully with
How is
correct
it,
instructions.
explain plain error to me?
Plain error.
Explain both, ineffective assistance of counsel and also plain error.
Okay, I'll begin with plain error, since your honor mentioned it first. As this court well knows, most recently in People versus Jackson and People versus Heron in numerous cases, there's two prongs of the plain error doctrine set forth in Rule 451C. The first prong is that this course, again, where there's been a forfeiture, where there's been an error, this court will reverse if the evidence is close, regardless of the seriousness of the case. And under the second prong, this court will reverse if the error was serious, regardless of the closeness of the case. And as I've argued in my briefs, either one of these can be applied to this case, has been applied in previous cases, certainly with respect to the closeness of the evidence. Even if this court disagrees with argument one, it's exceptionally close. In the motion for new trial, even the trial judge agreed that I think the quote, the ammunition evidence was a close
Later,
call.
Brother
I think it
Waffles.
was arguably thin. That's on page 171 of the report of proceedings. So regardless of how your honors feel about the first issue, we got to urge you to reverse outright. Under the second issue, it is first prong plain error. And it could also be second prong plain error for the reasons of the brief, because this is a central issue. This
So
is
if
the
an
only issue.
Failure to respond to a question from the jury is a second prong?
Not necessarily, but under circumstances such as this, where there is an IPI exactly on point and goes to the central issue of the case. Yes, absolutely, the precedents do allow this court to reach under second prong. But again, these are all just alternative bases to reach what's admittedly a forfeited issue. There's also ineffective assistance of counsel. Your Honor references the discussion at the jury instruction. I guess it's a conference after the no.
I mean, Brad, this case, oh God, I can't remember the original date, but this was actually in 2020, I think, when this came before the Illinois Supreme Court. I don't know whether there was any body worn camera of that, and that's something that I'll try to look into, and I hadn't thought about it yet. So if I can find body worn camera of this, dude, I would be really interested to see that shit.
Was received by the jury. Initially, both parties told the court, you have to give this instruction. It says they asked for it, you have to give it. Defense, true that at some point there was some disagreement about what should be given, right? Under the committee comments, the instruction has to be tailored to the nature of the offense. There's two paragraphs. One applies under certain circumstances, two applies under the other. But it's all clearly explained that the IPI Commission did an excellent job in this case, saying when to give paragraph one, when to give paragraph two. The state said, let's give paragraph one. The defense came back and they were unsure. They wanted both paragraphs, which is clearly wrong. Again, it would have taken 5 seconds to read the committee comments and see clearly paragraph one applies in this case. Then ultimately the state suggested, let's just essentially not give the instruction and tell them to go with what they understand. The state was making a strategic decision saying, we don't want to give this instruction. If defense counsel's not going to go for it, we're going to propound. The answer is don't give the instruction. And again, defense counsel went along with it.
Well, but defense counsel said that I don't know if it's a man or a woman, but he or she really was concerned with the second part of that first paragraph, that last phrase that we talked about a little bit earlier. I mean, clearly consciously aware, the attorney would have loved to have argued that and did argue that, but didn't want to be saddled with this substantial probability issue and how that might lead the jury down the path of conviction. And so you're sitting there, I put myself in the shoes of the trial judge and say, well, here's an attorney who's making a fairly reasonable argument not to give it in total. What do I do? And now you're saying that's error. And that's not only error, that's second prong plain error.
I mean, frankly,
I think at this point, I would argue that this is where juries, and God knows, oh man, the lowest common denominator in a lot of times is going to be picked for this. This is where juries actually need to spend some time thinking about this. Was this woman a threat? Is there any reason this woman should lose 2 years of her life to something like this? I'm sorry, is a FIOD card constitutional? If I'm on a jury for something like this, there's no way in hell I would vote to convict. No way in hell. It's probably why I'll never be picked for a jury. Well, we're going to play this some more.
regardless of the position of the defense attorney, under Childs, the judge does have a duty to give the instruction. The IP, as your honors well know, the IPI committee labors to come up with these instructions. Presumably they're based on the previous case, they're gonna have to labor to come up with another instruction based on what the Illinois statutes say. It's the job of the court to give the instruction. While it's understandable why there was some confusion or not want to give it in this case, that the framework of that is forfeiture. It's no different than the Heron case where the state proposed an instruction and the defense counsel just said, okay, I have no objection to that. Of course, that's how jury instruction conferences go, right? One party or the other proposes the instruction. The vast majority of them are not objected to. When they're not objected to, we look at who propounded the instruction. In this case, it was the state propounded the answer. We're not going to give an answer. And if defense counsel goes along with it, that's forfeiture. That's subject to plain error if it's closely balanced. Again, if your honor is not willing to find second prong, that's fine. It's clearly first prong plain error, though, because the evidence in this case, one, as I argued in argument one, is not sufficient to convict. But if it is somehow sufficient to convict, it's certainly closely balanced. So therefore, under the first prong of plain error, this court can reverse. And again, I would disagree that the analysis of the defense attorney was any sort of strategy, because it's clear he didn't even read the committee comments. I mean, we're talking about one page here. There's 2 paragraphs to committee comments. We've all seen them. If you read down the committee comments, it's plain as day what should be issued, when it should be issued. Both parties acknowledged at the outset the definitional instruction exists and that it has to be given if the jury asks for it. They asked for it. They struggled with this issue. It's the central issue in the case. And I'm arguing that they got it wrong. Part of the reason they got it wrong is they were never instructed on it. And
weren't they given a general instruction? Didn't the trial court say the, what is it, common meaning of knowingly?
yes, and again, I would refer this court to its prior decision in Childs, where this court said, quote, the issue is whether the instructions were clearly understandable to the jury. It's a fair statement. Apparently they were not.
The trial court did respond to the jury's query and instructed them to rely on the plain meaning of knowingly. So he didn't just not respond. He gave them an instruction to rely on the plain meaning of knowingly, correct?
There was a written question and a written answer. The written question was, what's the definition of knowingly? And the written answer were the word knowingly should be given its plain meaning within the jury's common understanding, which they don't have one. That's why they're asking. Again, referring this court to the quote in Childs. The issue is whether the instructions were...
At this point, sir, your time has expired and you may bring...
I'll bring it up later. Thank you, Your Honors.
May it please the court, counsel, I'm Assistant Attorney General Josh Schneider on behalf of the people of the state of Illinois. I'd like to start by clarifying what claims are properly before the court for its consideration, because we have no dispute there's a question raised about the sufficiency of the evidence, but the question of plain error is not properly before the court. And the reason it's not properly before the court is because it's not merely a question of forfeiture. It's because it's an invitation to have given the response that defendant now claims is erroneous, and that bars plain error review. And so the only way to reach the alleged instructional error is through the framework of ineffective assistance of counsel. So very briefly on the issue of invited error, this court has been very clear. Plain error review is not available for errors that were or alleged errors that are invited by counsel. And the reason is you can't ask the court to do something and then complain when it does it. And this case is a very clear case of invited error. The jury sent out its question, what is the definition of knowingly? The court and the parties put their heads together. They're talking about how to respond to this question. And actually it's the court that says, well, I think maybe we just look to the common meaning of the term. And it drew that conclusion based on the comment to IPI 5.01b. The prosecution says that it would be fine with that. Then the court turns to defense counsel, and defense counsel says, yes, I'd rather just have the jury define it for themselves, Your Honor. That's at page R139. The court then prepares some language to propose to the parties to communicate to the jury, floats it to counsel, and counsel says, quote, I agree with that. That's R140. The court then has a copy of that response printed out and given to the counsel to to look at. And counsel says, I agree with this, Your Honor. So if that is not affirmatively acquiescing to the response that the court gave, then nothing is. And this court in Averitt in 2010 said on essentially indistinguishable facts that it was invited error that barred plain error review. The court said there, where defense counsel and the prosecutor assisted the trial court in drafting its response to the jury's question, and counsel then agreed to the trial court's answer, that was invited error and not subject to plain error review. The appellate court has followed this court's lead repeatedly in cases that we cite in our brief at page 37, Peel, Lawrence, Curry, Hernandez. So plain error is not properly before this court. It's either sufficiency or ineffective assistance of counsel. Those are the claims that are really we're looking at. Since we just went through agreement to this, I'll start with the ineffective assistance claim. Counsel made a strategic decision, plainly, to ask that the court direct the jury to the common understanding of the term rather than issue IPI 5.01b. And this is one of the rare cases where we actually have some record evidence about counsel's deliberative process. Counsel tells the court in the conference, I'm really worried about this second sentence in 5.01b, where it's talking about substantial probability, and the court and the prosecutor immediately understand what counsel's concern is. So they say, yes, that awareness of a substantial probability that the ammunition was in the glove compartment does have sort of a flavor of recklessness. And so they put their hand.
Now, how do we, and this is, oh, fuck. Let me make sure I ain't muted for this one. So we'll flip back here. So he's starting to break into a recklessness standard instead of knowingly. Oh, I knew my husband had a gun and he transported, his gun in my car to the range to see his family. So I should have checked my car for bullets. Oh, this whole argument is so much bullshit. I can't even fit it into my fucking head. And I haven't listened to the whole case that we're listening to right now. I read through the court case itself. This is the first time I've watched the actual oral arguments of this. Holy shit, this makes my goddamn head hurt. What's up, Sunflower? So let me swap back here and we'll let this keep on keeping on.
Together to try and come up with a way to address his concern. Counsel was perfectly reasonable in not wanting IPI 5.01b, even if it should have been given. Counsel had good reasons not to want it given because it was a less favorable standard for his client. It is easier to find someone knowingly possessed ammunition in her glove compartment if one doesn't have to find she was consciously aware that it was there, but only has to find that she was aware of a substantial probability that it was there. And so counsel made a reasonable strategic decision. This court has been very clear, and Strickland itself is very clear, that we give great deference to counsel's strategic determinations. And the decision of what jury instruction to give is fundamentally a strategic decision for counsel to make. And defendant was not prejudiced by that strategic decision either, because again, the definition under the IPI is less favorable. And so had that IPI instruction been given, there was likely a greater chance that she would have been convicted than otherwise. The IPI, again, is conscious awareness that the ammunition was in her glove compartment, or awareness of a substantial probability that it was there.
Counsel,
Whereas,
what about this argument that, look, the jurors wouldn't have asked the question if they had a common understanding?
so
Therefore, it was no help at all.
it appears, and I think this is a reasonable interpretation of the question by the court, and both the prosecutor and the defense counsel seem to have understood the question to be asking, does this mean something different than it does in our usual day-to-day? You're in court, right? Does this maybe have some sort of special legal definition? And so they directed the jury to apply its understanding of the term in common usage. Now, the court's answer was not like the answers in Ayala and Sperry and Lowry, where the court said, you've received your instructions, essentially, go back and do your job. Those sort of discouraged follow-up by the jury. So here, if the jury said, what is the definition of knowingly? And the court said, the term should be given the plain meaning in the jury's common understanding. And the jury had no follow-up question. Then presumably it was satisfied with that answer. But again, there's no way to show that there's a reasonable probability that defendant would have been acquitted had counsel not made the strategic decision, because fundamentally the IPI instruction gave a less favorable standard for the defense. Under the common definition, if you look at any dictionary you care to look at, we provide a number of them, knowingly doesn't include knowing that there's a good chance or a substantial probability that something is the case. It's either conscious awareness, or shading the other way has connotations of intent or deliberateness. So I guess the analogy would be that if a person had been charged with knowing murder and the jury was instructed on intentional murder, there's no reasonable probability that they would have been acquitted had the proper, less demanding mens rea instruction been given, because they were convicted under the more demanding standard.
Holy fuck, man. It's very hard for me to state this without just going completely off the rails. I think that the only way I can really do it without just freaking wanting to just throw shit is, were there any victims? Was there any harm other than caused to the government? No. She's right near her home, very much in view of her own home in her own vehicle. And they still never talked about really what the cause for the search was in the first place. But even given that, it's still absolutely retarded. We're going to take this woman's freedom over 2 rounds of ammunition. We can't even prove that she knew was there. But hey, fuck it. It was written in a law book somewhere, and the majority voted on it. I'm real sick of this majority shit these days, because the majority of people out there in the general public are absolute fucking morons.
And so that leads me to the sufficiency of the evidence. There's no dispute that when defendant was stopped in her car, she had been convicted of a felony, and there's no question that when she was stopped, there was ammunition in the glove compartment of her car. The only disputed fact at trial and now is whether she knowingly possessed the ammunition that was in her glove compartment, meaning that she had immediate and exclusive control over the glove compartment, and that she was either consciously aware that there was ammunition inside of it, or was aware of a substantial probability that there was ammunition inside it. And when we look at the evidence in the light most favorable to the prosecution, drawing all reasonable inferences in the prosecution's favor, the evidence was sufficient for a rational jury to...
Okay, this is where we get into funny story time with Coop. Let me switch this back where I'm not looking at this stuff in fucking, seconds off. So years ago, I worked for a company that bought a new work van. New to us. It had been used before as a previously owned. And I, through my work, had to collect money from customers. I lost a check. Couldn't find the damn thing. I took the dashboard of this van apart. When I did, I found what looked to me like a really good full joint. However, to them, it was probably half of a joint. If I had been pulled over and a drug dog was ran around my vehicle, they would have found I had drugs in the vehicle. I had no idea that that was there, even though it was a previously owned vehicle. And I could have known, hey, this vehicle could have been used for any number of different purposes. Under this dickhead standard, I would have been knowingly in possession of drugs. And at the time, that shit would have put me in jail. You should have tore the van apart and looked for everything before you drove the motherfucker.
Find that she knowingly possessed the ammunition in her glove compartment as a felon in violation of section 24-1.1A1. Very briefly on the standard of review, defendant in her brief argues that we don't review the sufficiency of the evidence using the sufficiency standard. Instead, we should review it de novo, but that is incorrect. The case that defendant cites for that proposition, although they sort of nominally concern sufficiency challenges, they concern sufficiency challenges that turned on the interpretation of statutory language, not the interpretation of the evidence at trial. And the perfect example of this is in Ray Ryan B. There, the respondent had a stipulated bench trial, and on a charge that he had enticed or persuaded the child to remove clothing in violation of the statute prohibiting the sexual exploitation of a child. But the stipulated evidence was that he asked the child to remove clothing. And so the question was whether the fact that the stipulated evidence.
Yes, you guys are hearing this right. And I'm, again, reading the transcripts from this case. We went from a woman having 2 rounds of .40 caliber in her glove box and not knowing about it to a fucking pervert enticing children to take their clothes off. This is how fucked up our legal system is.
Showed, asking, was the fact that the statute required it to show, enticing or persuading. And so because that ultimately was a question of statutory interpretation, the court, of course, reviewed it de novo. But here, the court's not being asked to interpret the statute. All we're asking is, was the evidence of the requisite mens rea sufficient to prove that mens rea? And the inquiry there then is to look at the evidence of that mental state and ask, is that sufficient under the sufficiency standard? And here it was. First, the evidence was sufficient to show that defendant had exclusive and immediate control over the glove compartment because it was her car. She was driving it, and there's no evidence there was anyone else in the car. Now, defendant argued, I think for the first time in her reply brief, that she did in fact have a passenger. And she cites page R101 of the record for that proposition. But when we look at page R101, that is maybe not a fair characterization of the testimony. The officer is being cross-examined and asked 2 questions. First question is, now, all your interactions were recorded on your car squad camera, is that correct? Yeah. Second question, and there was someone else in the passenger seat of that vehicle as well, is that right? Yes, there was. And so the passenger seat that we're talking about here in context seems pretty plainly to be the passenger seat of the squad car in which the interactions in the back of the squad car were taking place. To the extent that...
What does that have to do literally with anything about her knowing she had 2 rounds of ammunition in her glove box left there by her husband, who is a legal gun owner, even to the point of having to get a firearms owner identification card? He has the 40 cal. He uses the car. What's up, DJ? What's up, Vanessa? This is just still shit to muddy the water on the fucking case.
And I think a good reason to think that is when we look at the opening statements, when we look at the closing arguments, when we look at the direct and cross-examination of defendant herself, there's never a mention of a passenger in her car. And that would have been an enormously significant issue for the defense had there been one, because of course, whether she has immediate and exclusive control of the glove compartment would look a lot different if there was another person sitting directly in front of the glove compartment of that car. But to the extent that brief passage is susceptible to different interpretations under the sufficiency standard, the court is compelled to interpret it in the light most favorable to the prosecution. So there's no question she possessed the ammunition. Now we'll turn to, did she knowingly possess the ammunition? And as is often the case, the question of the mental state turns on inferences drawn from the facts in the record. Here we know that she was driving her own car. She was by herself. That supports an inference that she was aware of the contents of her glove compartment. Certainly some people are not. That's another inference a person.
So again, I will use this example. When me and my wife first got married, I was a prohibited possessor. My wife used my truck all the time, went hunting in my truck, had ammunition in my truck. I found ammunition in my truck after she went hunting or something like that. Whether it's 22s for squirrel hunting, whether it was guns for her, deer rifle, whatever, bullets, rounds, whatever you want to call it. No big deal. I just, but it is what it is. However, if I'd been pulled over before I found those things and some jackass wanted to be an absolute dickhead like this cop did, well, then I could have went back to prison, even though I wasn't a threat to anybody. Now, to get into current events, the FIOD card, the Firearms Owner Identification Card, has been law in Illinois for a very long time. And we know good and damn well it doesn't stop a single fucking shooting. And now Illinois is trying to put in assault weapons bans and you name it, magazine bans, all this other stuff. And now they're getting stopped by the courts, thank God. But this woman still had 2 years of her freedom taken away by the state when there was no victim besides the state or the law. I don't get it anymore. After being where I've been, I just don't fucking get it. Because it hasn't stopped violent people from abusing innocent people.
Could draw, or compelled under the standard to draw the inference in favor of the prosecution as long as it's reasonable, and it's certainly not an irrational inference that a person knows what's in the glove
So when
compartment.
somebody's in a situation like this, then the person's automatically charged with knowledge of the existence of anything found in his or her car?
No, and I don't understand that to have been what the appellate court was suggesting either. A person has knowledge of something that's
Isn't that what the appellate court said, though?
I don't believe so, Your Honor. I believe they said that when a person, well, so on the facts of this case, the court was saying, here's this person, she's in her car. It's the contraband is in the glove compartment. It's not hidden somewhere where we might have a reason to think she doesn't know about it. And we have a specific reason to infer that she knew that ammunition in particular was in the glove compartment, because when she's told you're being arrested for ammunition, she doesn't say, what are you talking about, or what ammunition, or where. She says that belongs to my husband.
She knows her husband drives the car and has ammunition in it, so it doesn't mean that she knew that it was there.
It's certainly true that that is also an.
Okay, if you find tampons in my truck, I'm immediately going to go, those are my wife's. Why? Because I don't have a fucking vagina. Hey, yeah, it's the law.
Inference that could be drawn from the evidence. The standard, it's not a question
That
of.
she actually knew, or there was a possibility,
It's either that she was consciously aware that it was there,
or speculating.
or that there was a substantial probability that it was there. That's the statutory definition of knowingly. So all that the evidence needs to be sufficient to show is that she was aware of a substantial probability the ammunition was there. And although she asks this court to draw the inference that she just assumed that if there was ammunition in the car, then it must have belonged to her husband. And I think there's 2 + 2.
Too many, I'm on the fence with that. I've heard people say they're good for it. I've heard people say they're not good for it. I just have clotting gauze in my medical kits that way I can pack a wound with them. What's up, Bull Rush? What's happening?
I don't have guns, so if there's a gun in the car, it must be poisonous, that sort of reasoning. But that is simply a reasonable inference that can be drawn. That is not the only reasonable inference that may be drawn. And under the Jackson sufficiency standard, we must draw the reasonable inference in favor of the prosecution. It's not a contest. We don't say which is the more reasonable inference. All that's required.
So, not to talk about short, fat bastards, because I am one, but this little motherfucker is saying that, hey, if there's a little, unclear part of this, it ought to be found for the state, not the accused. I'm sorry, if there's any gray area in anything, it ought to go to the accused and not the state. The state should have to have 100% die-hard, concrete case with no vague areas whatsoever to get a conviction. If there is any gray area, the state should go take a walk, pound sand. I'm being as nice as I can. Will that lead to some very guilty people getting off? Yes, it will. And I've changed my mind about that over time. Will it lead to the state having a higher burden of proof on things? Yes, it will. But you know what? To take someone's freedom or someone's life in extreme cases, the state should have to have an extreme burden of proof. That's how you stop people from being put in prison for decades or put to death in some cases that were not guilty of their crime.
The inference in favor of the people has to be threshold of reasonableness. And this case is a good illustration of why.
Isn't the word knowing really important? Is because this liability was a charge and a penalty with it. So shouldn't the trier of fact absolutely know that person knew who was charged?
Well, that has to do with the question of the jury instruction. The sufficiency question is an objective inquiry. Could a rational jury have found this evidence sufficient? And we would submit that a jury could. And again, this is a case that...
Vanessa, this is Illinois. This is under the firearms owner identification stuff. And in a lot of law, I think even federal law, if someone is a convicted felon, they cannot own ammunition. Not just the firearm. They can't even have ammunition. If they have ammunition, that is just about as bad as having the firearm itself. Which, again, story time with Coop. I had a 93 Ford when I got locked up. I squirrel hunted, I deer hunted, you name it. That truck had been cleaned multiple times when I was incarcerated. And when I got out, I still found 22 ammunition and some other ammunition in my truck. Because, holy shit, if you're, got your pouch in there where you're dove hunting or squirrel hunting, you have loose shells, they fall out. If you've got your bag in there, your, gun case, stuff falls out, stuff falls behind seats, you name it. If you search someone's car for almost an hour, holy shit, the amount of stuff you can find. But hey, if the state is the victim, goddamn, someone's got to go to fucking jail.
Really explains why the sufficiency standard works the way it does with viewing the evidence, because it's a very favorable standard for the people. There's no question.
Well, I agree with you on that, but in this particular case, the jury wasn't instructed with the proper definition of knowing.
Well,
And that's the issue, because ultimately this woman was convicted.
That's true. They were not given the IPI because counsel agreed that they should not be given the IPI. And the reason that counsel agreed to that was because the IPI would have made it more likely she would be convicted. So to the extent that there was an error in the definition of knowingly that was given, it was an error that inured to defendants' benefit in the weighing of the evidence. The
See,
reason
I don't understand how you can say that. I mean, knowingly was, or knowing was a critical aspect of this case, the most fundamental critical aspect of this case, correct?
yes, the question was, did she knowingly possess it?
And so when they're not,
Dude, there's been so many cases before I was in trouble and after I got out of all that shit, where I've had loose ammo on me and in my vehicles. It's not even funny. Long before I got in trouble, I went to go pick up my girlfriend's grandmother from the Atlanta airport. I went squirrel hunting that morning. I had a pocket full of at least 122 rounds right before I went through the metal detectors at the Atlanta airport. And I dumped most of them bitches out. And then I still had at least 4 rounds in my pocket with my change when I went through the metal detector. Luckily enough, that was before 9/11, so they didn't shoot my ass. And I just told the lady, hey, you keep them. And went on about my business. It's just, I swear it makes my head actually freaking throb with the amount of laws that these people put on books that don't stop the criminal. However, they take someone who is a felon, who's not on probation, who apparently has no violent history, and you put their ass back in prison over some stupid bullshit. Nothing I read about this lady said she was violent, that she was a threat to society. She had a freaking non-violent identity theft case, which, okay, maybe she was a douche at one point in her life. Maybe she got her shit together. She was married. Her husband had a firearms owner identification card, which is fucking stupid to me. Unbelievably stupid to me. Her name was on the vehicle, but as those of you who are married understand, if you have 2 vehicles, each of you use each other's vehicles. That's not out of the realm of fucking possibility. And she gets trapped up behind this bullshit. I guarantee you I could go to my truck right now and probably pull out at least 3 different calibers or gauges of ammunition. Just because, shit, they fall out of range bags, they fall out of vests, they freaking, again, the insanity behind this.
instructed on something that's so fundamental like this properly, doesn't that cast doubt on, you would say the evidence is sufficient? Well, the evidence is sufficient given everything and given our standards. But when you don't have a definition of something that's so highly critical, doesn't that call into question the integrity of the conviction itself?
No, for 2 reasons. First, I want to be very clear that the question about the instruction is irrelevant to the sufficiency inquiry.
Oh, I understand that.
So
they're 2 separate questions.
The-
So I'm not disagreeing with the sufficiency of the evidence. I'm talking about, in this case, they didn't give a proper instruction, on that one critical point. And that is a critical point
Sure.
in a case like this.
Sure. And so first of all, the reason that didn't happen is because counsel agreed that it shouldn't happen. And the reason counsel agreed it shouldn't happen is because the second basis on which a person could be found to knowingly possess something is if they are aware of a substantial probability that it's in their possession. So counsel reasonably did not want that definition given because I know there is a reasonable probability that I have a tire gauge in my glove compartment. I don't know for a fact that's the case. but that means, I know there's a substantial.
Honestly, for the people of the court, does this dude look like he has ever changed a tire or checked tire pressure? Because no. The only callus he had on his hand is if he ran out of lotion and had to stroke it.
Probability rather, that there's a tire gauge in my glove compartment. That makes me, if that were a crime to have possession of a tire gauge, if I get in the car, I am guilty of that because I know that I'm aware of a substantial probability that it's there.
But you don't know.
Well, I do under the statute. Knowingly under the statute means that you are aware of a substantial probability.
So it's speculation again.
Well, it's not speculation, it's drawing inferences. So, for example, here we know that they've been married she and her husband, who has the gun and ammunition, have been married for about 10 years. We know that she knows that he transports his guns in the car. He says, whenever I transport my gun in the car to visit the children in St. Louis, I put the ammunition in the glove compartment. I've been married for about 10 years. It is remarkable how much my wife knows about my various habits, quirks, neuroses, and it's because she's lived with me for 10 years and is a reasonably observant person. So it is not an irrational inference for the jury to think. These people have been married for 10 years, they live together, they have children together, they share this car. We think that.
Okay, I'm gonna let this play for a minute. And I kind of got to collect a thought here. And I'm not talking about that hoe over there. I'm talking about an actual thought. I'm at the restroom. I'm going to let this play, and I might back it up to this point. Because this dude says he's been married for almost 10 years and talks about his experiences. Okay. Y'all give me a minute. Let's let this play. Hold on, where are we at in this argument?
We think that if she knows he transports his gun in her car, that she's familiar with his habit on how he does that. It's not the only inference that a person can draw, but it's not an unreasonable inference, and that's all that's required.
See, I'm worried that if we agree with you in this case, what does that do to all the cases dealing with when there are 2 or 3 people who own the car, they drive the car, and so that they because of that, they're aware all the time of anything possibly in the car, unless it's some hidden in some kind of dark corner. They're just aware of everything, especially if it's in the glove compartment.
Right. So that's actually, I think that concern is not actually implicated by this case. Because so most of the cases where we see constructive possession being at issue is where, for example, there's more than one person in the car, or there's circumstances where.
But it's knowingly, it's not constructive possession. It's what the person knew.
Well, constructive possession, knowing possession can be constructive. So constructive possession means that it's not physically on my person. It means I have immediate and exclusive control over the area where the contraband is.
But you don't know the contraband's in there.
No, I have to for it to be knowing possession. I have to either be consciously aware that it's in the glove compartment that I have control over, or be aware there's a substantial probability that it's there. That's the statutory definition of knowingly. Had the IPI been given, that's the definition.
So every time I get in my husband's car, I'm supposed to know what's in his glove compartment, or be aware, or there's a probability there's something that shouldn't be there?
No. So the question is extremely factually specific. So whether a person has substantial reason to believe that there is
due to all the cases dealing with when there are 2 or 3 people who own the car, they drive the car, and so that they because of that, they're aware all the time of anything possibly in the car, unless it's some hidden in some kind of dark corner. They're just aware of everything, especially if it's in the glove compartment.
Right. So that's actually, I think that concern is not actually implicated by this case. Because so most of the cases where we see constructive possession being at issue is where, for example, there's more than one person in the car, or there's
Yep, you're right. I was muted. So and I forgot to unmute. But I shared a truck with my wife for a very long time. I cannot tell you the amount of items that my wife has left in my truck from one given time to another. I've torn my truck apart because I had a fucking hamster loose in it. And for those of you who don't know what a hamster is, it's a short-tailed rat. And I had to take my back seat out of my truck to find this goddamn hamster. And I was pulling chapstick and perfume bottles and all kinds of shit out of my truck that I had no idea was there. Do I have sound now, kids? I should have it now. But Jesus Christ, if you're saying that if she shared a car and her husband drove it sometimes, even though her name was on the car, that she should know everything that's in that car from one given time to another, Jesus Christ, can you be that much of a fucking moron? And this guy answers that question. Yes, you can. Because he's on the side of the state taking a woman's life away for 2 years over 2 rounds of ammunition that were no danger to anybody. No, Bull, don't go there. I was not Richard Gene in it. This joker was stuck in my back seat, not the prison wallet. There's a difference. You dirty bastard. We ain't going there. And Richard Gere was gerbils, not hamsters. He was a gerbil runner. Now, I'm pretty sure he could probably run guinea pigs, but hey. Just saying.
Circumstances where...
But it's knowingly, it's not constructive possession. It's what the person knew.
Well, constructive possession, knowing possession can be constructive. So constructive possession means that it's not physically on my person. It means I have immediate and exclusive control over the area where the contraband is.
But you don't know the contraband's in there.
No, I have to for it to be knowing possession. I have to know, either be consciously aware that it's in the glove compartment that I have control over, or be aware there's a substantial probability that it's there. That's the
substantial probability. How shall I put this, kids? I really don't know how to put this. I have given people rides home from work that I knew were people who did drugs. I didn't. But if I got pulled over after they left something in my vehicle, well then, hey, he should have had knowledge, or there was a substantial probability that there could have been drugs there. Even though they're not mine, I wasn't doing them. I had really no idea dude left his bag in my truck, but he was a sketchy motherfucker. Why would you give a sketchy motherfucker a ride? Well, because I'm a goddamn dumbass. It was raining. Dude needed a ride. I gave him a fucking ride. The more I get into this case, the more I actually look into this entire thing, the more it pisses me off of and yes, Mike McClune, $20 is $20. I'm just saying it'll buy a pretty good case of beer for $20.
statutory definition knowingly. Had the IPI been given, that's the
So
definition.
every time I get in my husband's car, I'm supposed to know what's in his glove compartment or be aware, or there's a
No.
probability there's something that shouldn't be there?
No. So the question is extremely factually specific. So whether a person has substantial reason to believe that there is particular contraband in any particular place turns on the facts and circumstances of that case. The cases that defendant cites are really good examples of how this works. In Hampton, a defendant borrowed a car that he had never driven before, and minutes later, I don't know, 2 or 3 minutes later, he's stopped by police and they find a firearm in the glove compartment hidden in, I think it's in a sock. And the court said, there's insufficient evidence to find that the person, may I complete my response? There was insufficient evidence for someone to find that person who had borrowed that car he'd never driven before knew that the gun was there, because there was no reason for him to know it was there. Where a person shares a car with one other person, and under these facts, she knows that he transports a gun, and we can infer knows.
She knows her husband has firearms. He transports them in her car. He knows she is a convicted felon. He has a FIOD card. He is obviously aware of the laws. She thinks automatically, hey, my husband would never leave things like that that could automatically put me in jeopardy in my car. You could argue this either way. And the goddamn thing of all this is the fucking state will argue it any way they want to. And the answer always is the state's right. And they use your tax dollars to put your fucking happy ass in prison over things like this. Your money funds that little dude right there, little goblin looking motherfucker, to put your ass in prison. And yeah, it's a state arguing at this point, crew.
He transports ammunition, there is substantial probability that it's there, and a rational jury could believe that she was aware of that substantial probability. And so for those reasons, we ask that the court affirm. Thank you.
Thank you very much. Counsel, in reply? Counsel, can we start with the first issue of sufficiency? What is our standard of review?
The standard review, if the facts are not in dispute, is de novo, as indicated by this court, People versus Smith. However, if this court's not willing to go there,
Sufficiency of the evidence is de novo?
it can be if the facts are not in dispute. If this court is not willing to go that far, that's fine. It doesn't really change it. Under the regular standards of sufficiency, where the facts are in dispute, there still has to be enough evidence to prove that there was knowing possession, and here there's simply not.
Standard review, right? Is that the language we use for standard review, or are we talking about the Jackson standard? What we must resolve whether, after viewing the evidence in the light most favorable to the prosecution, any rational trier of fact could have found the essential.
Why is any criminal case decided in the light most favorable to the prosecution in the first goddamn place? The prosecution, the one wanting to put you behind bars, take your freedom, destroy your life, should have the highest bar possible. It's like we talk about in cases of pistol braces and other things. If there's a vague area in the law, which there shouldn't be, that vague area ought to go to the accused, not the state.
Elements of the crime beyond a reasonable doubt. Is that the standard review?
I agree. The Jackson standard review is the law of this land and applies to the vast majority of sufficiency cases. It is true, however, that this court has applied de novo review to sufficiency arguments in the past. I'm just answering Your Honor's question. I don't mean to belabor the point. It's not necessary. Even under the Jackson standard, the evidence just simply isn't there to show that she was consciously aware that the bullets were in the car. Okay. So very briefly, I'd like to get back to the second point, something I tried to get out in my opening, didn't quite get there. Rule 451A of this court says that an IPI, quote, shall be issued unless it's an inaccurate statement of the law. The definition of knowing in this case clearly is not an inaccurate statement of law. It just tracks the language of the statute. As this court said in People versus Childs, The issue is whether the instructions were clearly understandable to the jury. Apparently they were not, or the jury would not have asked the question that it asked. That's page 231 of chapter.
Crow, and we see this now, if a DA decides that a law is just bullshit, yes, that's when you get into prosecutorial discretion. And we see this with people who are caught on many things and have firearms with them. And DAs have decided, hey, we're just not prosecuting that. DAs, in a lot of cases, have the discretion to prosecute or not prosecute. In a lot of ways, DAs could be our first line of defense against things like this. In other words, if you elect DAs or you put in place DAs that are going to abide by constitutionally righteous, I should say, laws, then yes, your DA could be the first line of defense saying, no, I'm not prosecuting anybody for that. There was no victim. The state was the only victim. So, fuck that. I'm not prosecuting that. DAs could do that. Your cops, your police officers could, if they actually respected the Constitution, not even write out the paperwork on it. In other words, this cop or these cops who pulled this lady over not too far from her house searched her car for almost an hour, found 2 rounds of 40 caliber ammunition, could have given her those 2 rounds of ammunition and said, hey, lady, have a good night. But no. This is where you get into the law is the law. I'm sorry. Your laws are unconstitutional. Your laws are bullshit. And nobody should be prosecuted under these laws. Again, jury nullification. Was there a victim other than the government? No. Well, if I'm sitting on that jury, I'm thinking, nope. Not guilty. But they found him with the 2 pounds of cocaine. Not guilty. If you want to get them on something, you get them on the violent crime. You put the gun in their hand, the gun to someone's head. I will vote them guilty all day long. But there has to be someone else injured other than the state. Yeah, dude, the cops have that discretion. They can do it. I know a guy, he was a cop. He actually went from being a cop and transferred to the fire department. And he was telling me about this thing. They pulled some cats over one night, again, story time with Coop, where they pulled some guys over. They had weed in the car. Now, the dude just made like an illegal turn, didn't use his blinker, whatever. They pull the car over. They smell weed. They search the car. They find a bag of weed. And dude was telling me, he was like, man, my partner wanted to like do paperwork, throw him in jail. It's like, this is the weekend. I think it was a holiday or something. He said he just tore the bag open, threw the shit in the grass, stomped it down, and was like, nope, no weed here. We didn't test it. And his partner was throwing a fit. Why? They had weed in the car. Weed's illegal. And he was like, nope. Sorry, it's stupid. They weren't harming anybody. Why am I going to spend my time filling out the paperwork, going to testify in court, trying to put these guys in jail when they aren't a threat to anybody else? That's how free-thinking people operate. However, you have those that are of 2 minds, I shall say. Some say because it's in black and white, oh, we should do whatever. And others go, well, if it's black and white, but I can add something into it, well, then we have the power to do it. both of which piss me off of
That's exactly what we have here. The jury was unclear what knowingly means. They went to the judge, said, please tell us, and they didn't get the answer they're entitled to. Now, returning now to the first issue.
Well, let's stay on the second one just for a second.
Sure.
Because counsel argued that plain error doesn't apply because it's invited error.
Okay.
Your response.
Yes. So invited error occurs where the defense attorney is the person who commits the error. So the classic examples are admitting an improper instruction or insisting on a certain defense be propounded or not be propounded. It's just a simple equitable doctrine. It makes perfect sense for this court to say, if you go into court and submit the instruction yourself, you cannot then go up on appeal and say, I committed error by submitting that instruction myself. That's just simply essentially an exception to the plain error doctrine. That's true. It's not what happened in this case, however. Even counsel points out it was the court and then eventually the prosecutor who initially said, which is the issue for invited error, we're not going to give the IPI. And it's true that defense counsel went along with that, just like defense counsel goes along with erroneous errors in numerous cases that amount to ordinary forfeiture that's subject to the plain error doctrine. Even this court's, I would say, the leading plain error case that this court issued, People versus Heron, was this sort of instructional scenario. The instruction was submitted not by the defense attorney, and the defense attorney simply said, okay, no objection, judge. Again, this is what we see every day. There's jury instruction conferences. Somebody propounds it, you object or you don't object. Typically, you don't. There was no objection here. So therefore, it's not invited error. That's a very narrow, equitable doctrine. And as this court explained in Heron, it's narrow for a reason. It's narrow because this court recognized, quote, forfeiture is a harsh sanction for a defendant whose attorney failed to raise the error in the trial court. So therefore, it should be limited. And that's why the plain error doctrine exists. Obviously, these things happen.
Well, that's why you have ineffective assistance also. So
Yes, correct.
The defendant's not left out in the cold.
Exactly. There's three ways you can reach it. You can reach it under first prong plain error, second prong plain error, or ineffective assistance of counsel, all of which are raised in the briefs properly before this court at this time. Returning to the first issue, counsel mentions he knows he's got a tire gauge in his car. Why does he know that he has a tire gauge in his car? Because he put the tire gauge in his car. There's no suggestion that Mrs. Jones put the two bullets in her car. Counsel talks about competing reasonable inferences. We have all of the evidence points to the husband accidentally left the bullets in the car. There's no even suggestion that she put the bullets in the car. His wife might know about his quirks, but his quirk isn't, I have a tire gauge located in my car.
Well, it seems the position is the request to the court is to find that if you have co-ownership of car, two people drive the car, or three people drive the car, for example, and you've got one person who uses drugs, then you're on notice if you drive the car that there might be a likelihood of drugs in the car. Would that be fair?
Even further than that, the state's arguing that there's actually an affirmative duty to search the car and look and check to see whether there's drugs in the car.
How many sufficiency of the evidence cases do you think this court takes up? Just straight with no other issue.
In a given term, not very many.
I'd say probably close to zero.
Yeah.
So the reason for that is because they are so fact specific, and they don't give us any major precedent because they can always be distinguished on the facts.
I agree in those cases, but I believe this court took this PLA for a reason.
Well,
and the reason being that this case does have broader implications. Those implications being, as Justice Burke pointed out, if she takes her husband's car and he left his handgun in the glove box, forgot to take it out, she doesn't know that. She's not consciously aware that he left his handgun in the glove box. The state's essentially arguing for, if you affirm this is what the broader implication is. If you affirm Mrs. Jones' conviction, what you're saying is that Justice Burke was guilty of a crime. If she doesn't have a FIOD card, I don't know if that's true. She's guilty of a crime. I submit that she's not. Just another example, because there are many examples, which I'm sure your honors can clearly see. A 16-year-old borrows her dad's truck. He went on a hunting trip that weekend. He took his shotgun out of the car. He took most of the ammunition. One of the shells rolled under the seat. Look, she knew her dad went on a hunting trip. This is what the state's arguing. She knew her dad went on a hunting trip. Therefore,
we're not a jury.
I'm fired up, frankly, because the fact that my client stands convicted in this case is outrageous. She's not a criminal in the same way that Justice
Dude is 100% right. 1,000% right. It's say if Alabama passed a law that said it was illegal for children the age of 21 to own firearms or ammunition, and my daughter 10 years from now, she's 16, she borrows my truck and she gets caught and there's ammunition in the truck. Well, you're not old enough to own this. Well, therefore, you're going to prison because you should have known your dad was a hunter, your dad had ammo, your dad shot guns. It's a ridiculous argument. And who is the victim but the state? And the state should never be held as the victim in a criminal case like this.
Burke is not a criminal in the same way that a 16-year-old who borrows her dad's truck is not a criminal
What
simply
happens when
because.
someone, the police come to an apartment and they search the apartment, and in one of the bedrooms, they find drugs, and then they also find a lease in the defendant's name?
Yeah.
Have you ever seen a case?
All right, since the Morning Star showed up late, we'll go through this real fast. Okay. This lady had a prior felony for a nonviolent identity theft case. She got pulled over in a car that her husband, she had title to, but her husband used sometimes. They found 2 rounds of .40 caliber in her vehicle and then charged her with possession of ammunition and sent her to prison for 2 years over 2 rounds of .40 caliber. That's the whole gist of this case. She didn't know it was there. The cops spent almost an hour searching her car to find it.
Like that?
Sure.
what
The case
happened?
in the brief, People versus McCarter.
And what happens?
In that case, the defendant was found guilty because there was a specific bedroom, and Your Honor, seen many cases like this. The evidence in the bedroom is closely associated only with that person. For example, if there's a man and woman living in a house, they're not married. There's 2 bedrooms. One bedroom only contains men's clothing, or a lease,
Are
or
there any other cases where the only evidence that the state presented was recovery of the drugs and a lease? And this court, not this court, but the appellate court has upheld those over and over again, because there's an inference that can be drawn.
there's an inference if it's multiple bedrooms and multiple people, or if there's only one person. This is a shared car. This is not dispute that she shared.
Does she have, in that moment, does she have exclusive control over the car?
Yes.
Isn't that an element substantial of
So, according to this chick, who is a judge, my wife could borrow my truck right now. And if my prescribed medication was in that truck and she got pulled over going to the store, and the cops saw there was prescribed medication in the truck that was not hers, they could arrest her for having drugs in the car that were not hers. Even though we both drive each other's trucks, she knows it. She just didn't search to get everything out of her truck before she left to go to the store. Holy shit. Is that the dumbest God? Never mind. Let's get back to this.
It's not the only element. What we're focusing on here is knowing possession. Did she know? Was she consciously aware? Was there a substantial probability? The state argues that it's difficult. This is a bad standard for the defense. It's not. Knowing is a very high standard. This isn't a civil case. We're not talking about, certainly not strict liability, although the state's argument calls that into question, but not negligence, what she should have known. It's knowing. It's the highest standard, right up against intent. It's not probability. It's not possibility. It's substantial probability. The evidence in this case simply does not rise to that level. And if it does, by affirming a conviction based on such scanty evidence, this court opens the door to a wide variety of convictions based on totally innocent conduct. Thank you, Your Honors.
Thank you both for your spirited arguments. This case, number 127810, People versus, State of Illinois versus Toronto Jones. Agenda number 11 will be taken under advisement.
All right. So again, I'll have to look it up. I'll have to see whether I believe the Supreme Court of Illinois has actually upheld her convictions. She actually did all the time that was involved in this case. So she did 2 years for 2 rounds of ammunition that she really didn't know was there. Comes down to it, I really don't care whether she knew it was there. Was she firing that ammunition to harm innocent people? No. Okay. Then I really don't care. You know, there was a time, and this is an admission of Coop's life, where I actually believed that laws were there and laws protected innocent people, and we could believe in the so-called justice system. I actually believed that for the vast majority of my life. Even my own conviction, my own time in jail, prison. I did what I did. You know, I'm different than a lot of people. I did what I did. I served my time. Paid for it. And even beyond paying for that time through the justice system, I paid for it personally. Kicking myself in the ass, just degrading myself. All kinds of stuff comes into that. But I did that. I did my time. I paid my debt to society. I'm no danger to any innocent person. I fought for a long time to get my rights back. But in the end, it came down to money and a lawyer that got me my rights back. Tell me where that's just. Tell me where the money and being able to get a lawyer to get your natural rights back is actually a just deal. It's not. So here's a person in this case, no threat to anybody. Shares a car with her husband. Her husband shoots. Her husband is a legal gun owner. And yes, you can live with a legal gun owner when you are a felon. Been there, done that. You just have to make sure that the firearms and ammunition are technically outside of your realm of control. I've been there. But tell me how something like this is just. Just. Meaning it is defending the public from some unjust act. She wasn't pulling drive-bys. She wasn't a threat to other innocent people. Yeah, Mike, it's a game of money. That's what our so-called justice system has turned into. We have a legal system, not a justice system. Now you look at Illinois. Well, they went from firearms owner identification, and you have to have proof of ammunition ownership and all this shit to now they want to ban assault weapons, so-called assault weapons. make you a felon if you own anything that they don't like. And the regular old handgun, which I have a couple sitting here, are used in the vast majority of crimes. So you guys explain this stuff to me rationally. Because I used to believe in it. I used to buy into this stuff. Oh, the law is there to protect the innocent and all this other shit. And trust me, I do believe in taking violent people and locking them away for vast amounts of time. I do. I do not believe in taking nonviolent people who are not threats to the general public and locking them away. So, anyway, guys, I'm going to end this one here. This was just another share the pain stream. Hey, we'll share something out. I've got another couple in the works in the next little bit. And then I've still got to get back on top of paper cuts and going over the proposed laws and stuff that are in Congress right now. So, yeah, I'm going to end this one. But just food for thought, guys. Think about this stuff rationally. If someone is not a threat to the general life, liberty, or property of other innocent people, do they deserve to, go to prison for a couple of years? My answer is no. Now, I hate a thief. I hate a thief with a fucking passion. Because even identity theft, there is a victim there. You stole someone's stuff, whether you did it online, whether you did it in person, you still stole someone else's stuff. You still took something that wasn't yours. And I believe you should serve time over that. So don't get me confused with saying, well, hey, no one was. No. I believe that you should prosecute criminals. I just don't believe you should take someone who is no threat to anyone else and you should take their freedom and their liberty just because the majority of the people voted on it. So, you purse be cool. I say it all the time. You purse be cool. Keep that thing on you at all times. And we'll catch up after a while. Love all of you guys. You guys are the most awesome people on this planet. Catch y'all guys after a while.